But pointing a gun at somebody and threatening them, that's just a mistake, a click away from the death penalty.
This isn't just another robbery case. This is a man pointing a gun at his own family. Excuses are coming, mental health is coming, wrong crowd is coming, but the judge isn't buying sympathy without accountability. And when the victim is your cousin, that changes everything. Watch how fast this turns from explanation to consequences.
Now, we recall 24 CR 1326, the state of Texas versus Dustin Jones Jr. That is you, sir?
Yes, sir.
With Bruce Smith, your attorney. The state's attorney was here. Earlier, you were charged with an indictment of the first-degree felony of aggravated robbery. And we had a plea hearing here earlier, and this is dated May 26, 2025. In that case, you pleaded guilty to the first-degree felony as indicted of aggravated robbery. And there was a plea bargain that had been entered between the parties where whatever punishment would not exceed a cap of 8 years in prison. Is that your understanding of what happened back then?
That's back then. Yes, sir.
Now, that's the issue here. The parties now state, the state and the defense agrees that the agreement is a cap not to exceed 6 years.
That's correct.
In prison. All right. I've got these papers dated May 28th. And what happened is we did not go through the punishment. Why was that? Does anybody remember?
Don't remember.
Do you remember? We had the plea hearing, and that was the last back in May, about a year ago, and you've been in custody, right?
Yes, sir.
But I'm looking at the pre-sentence report that was prepared, and you had an aggravated robbery case pending in Harris County and an unauthorized use of a motor vehicle in Harris County. Did that get disposed of?
No.
You've been in Jefferson County this whole time?
Yes, sir.
So whenever we get through with this case, is Harris County going to?
Yeah, I have
Deal with it?
12,000 times Harris County. Nobody will talk to them because I'm not the attorney of record over there.
Okay. All right.
I think, Judge,
Yeah,
the victim in this case
never happens.
The victim in this case is his cousin, and the cousin was saying that he no longer wanted to prosecute, and
But
there was all kinds of things that were happening, and somehow this is where we're at.
well, when it gets into the hands of the district attorney,
Yeah.
the people don't get to decide. The elected officials who are in the executive branch of government, the district attorney's office, they get to determine what is just in proceeding. And we're moving forward one way or the other here. But this punishment deal, I'm going to correct it to 6 years. Correct, everybody?
Yes, sir.
Yes, Your Honor.
Corrected this date. And this will be put into the file system somehow, but make sure that it's for all posterity.
But we cannot copy.
And also, it goes on, the agreed punishment recommendation goes on to state that the defendant is seeking community supervision probation. So we're going to do this just one more time to reaffirm everything. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary on this?
He does.
And the defendant is present. This is attorney, Mr. Smith, and the state's attorney. In summary, this indictment alleges that on or about April 28th, 2024 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery. Do you understand what you are charged with?
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, and whatever sentence shall not exceed a cap of 6 years in prison. So you would be looking at
Goes fast.
no less than 5 nor more than 6 years in prison,
That's correct.
then deferred or unadjudicated probation can be an option. But because a deadly weapon or a firearm was used, regular probation is not an option.
Correct.
So those are the two options that we would be looking at in determining what the punishment shall be. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead again to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Pleading guilty voluntarily because I'm guilty. Yes, sir.
I show you what's marked here as States Exhibit 1. Did you sign that document? Back in, looks like May 28th of last year.
Yes.
Did you understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence.
Okay.
Without objection, it is admitted. Among other things, this states that you are mentally competent to enter your guilty plea, and it's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states at the bottom, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
No, Your Honor.
No, Your Honor. It's made a part of the record then for all purposes. Okay. State may go first and last. What's that, State?
Judge, when you look at this, we've got all too common a scenario these days of people using guns. And in this case, they used it. And of course, we're talking about this man's own cousin that he ends up robbing him and taking, I believe it was approximately $800 in cash and a pink cash app. There was some stuff that was taken from them. And somewhere we just got to put people away when they just end up robbing their own relatives at gunpoint. It's just kind of sad. So we would ask for the 6 years.
Kind of ruins the family unit there when that happens. It's bad enough if it's somebody you don't know, but if it's somebody you do know, I mean, number one, they're going to be able to identify you. And number two, it doesn't do well for a good family unit, especially at Easter or Thanksgiving or other events where the family gets together. Anyway, what's the?
Your Honor, as far as the
How much
cousin
time does he have
situation,
credit, please?
there was several other people there that the defendant had gone to the cousin's house. And when all of this went down, my client did not possess any type of weapon, but everybody ran off after the deed went down. My client, he has no prior felony convictions. He was handled as a juvenile, got deferred, and all that went well. But since that time, he has not had any problem. In fact, he had, up until all this stuff started happening, he excelled. His background, he had dyslexia in elementary school. But he still graduated from a homeschool program in 2024 with a degree. He has lived with his grandmother prior to jailing. She's very supportive, and she has helped, financially support him. In his youth, there is a history of mental health problems. He was having auditory hallucinations, and he received mental health treatment through MHMR. For those.
What was the diagnosis? What caused it?
It was schizophrenic.
Well, I mean, that's something people are going to have their whole life sometimes if they're not treated. But what caused it? Has he been a schizophrenic all of his life?
They don't know, Judge, and the grandmother doesn't know. It's just that he was, when he was a teenager, he started hearing voices and whatnot, but things got better, and except when he was 17, He was shot 3 times in the stomach, chest, and left arm by Jerome Wilson over silly things involving Wilson's girlfriend. So even with all of that, we have we have proof here showing that this young man has, in 2014, he received a school award for the most improved student, reading program, math achievements award. In 2016, he received a certificate of participation for science achievement award, a certificate of achievement, recognition certificate in perfect attendance, and certificate of excellence. He, from 2019, 2020, he was on the AB honor roll. He obtained his barber license. We have given, I don't know, we probably may not have, but the DA has it. There are supporting character letters that are contained in that document that are just handed to the court. And it talks about how influential he was and how active he was in church, and how active he was with the youth and the youth program. And then this problem developed, and so I can't tell the court that this is happening because of the confusion with his mental health condition and whatnot. Coming in and out, he has problems that has to be handled. But with his background and the people that I've talked to, he is very, very capable of following the rules of probation. He has been in jail now for a very long time here in Jefferson County, but we still believe that he could be a very good candidate for probation. He did have a court-appointed attorney in Harris County on those charges over there. I'm getting all kinds of mixed reports about those charges over there.
Those haven't been disposed of.
They have not been disposed of, but they're pending.
And there was a failure to appear in those cases before this.
But that was because he was in jail here on the failure to appear. So we believe that this young man, Judge, would be a good candidate for probation. And in the PSI report, it makes reference that he has no past. PSI itself shows that he has no past records of any kind of violent offenses. The juvenile record stuff are non-violent offenses. And it shows that he has great and stable family support here. They were quite impressed with the fact that he did complete that homeschool program, even though he had the problems that he had, like with dyslexia going on.
Hold on. So, let me just dialogue here. Just say, I know what you're saying. All this support. What the heck is he doing? Robbing people. With all this support. Come on. That's pretty clear that that's not the right thing to do. And how is this person related to you?
He's a cousin.
Cousin. So much for the family unit. That's terrible. You shouldn't harm anybody, much less a relative. Go ahead.
So, with all that said, judges, is that we, we've talked, to the cousin. The cousin doesn't want these charges to proceed. He's talked to the DA's office as well.
Well, that's not the way this pre-sentence report reads.
Well, I understand, but
he wasn't. He was anxious. He was dropping a dime on the defendant then. I'm sorry. Yeah, he was dropping a dime on the defendant then, as it were.
Since that time,
he believes his cousin orchestrated the whole thing.
Since that time, the cousin has even confirmed to the district attorney's office that he does not wish to charge.
I know. We see that all too often.
I understand.
And that could we all know what's probably behind that. There's always pressure within the families to try to fix things, especially if it's been familial. But The problem is that this started out with people making sworn statements of what happened, and they were standing by it through the whole case, through the plea. And now later, they're reflecting on whether that was the best thing to do, but you have to rely on, sworn facts, and what we have here is a very disturbing group of individuals who got together and committed a very serious offense. And of all things, the victim is your cousin.
If I may, Your Honor, how long have you been in the jail now?
A year, like,
He's got 600 days credit.
So, I've talked to him at length with his grandmother at length. And he tells me that, since he's been in jail for so long and whatnot, he knows he wants to go back to that quality life that he had. He knows that he could do it.
I would hate for you to say, I'm enjoying the heck out of prison and jail. Can you add more time? Sometimes people say that. I'm glad you're not saying.
Is there anything?
Freedom is a special thing, but you have to follow the rules like we all do. And yeah, and here's the problem. If somebody would have shot a gun and killed somebody, you'd have two choices: death penalty or life without parole. That would be the only choices forever.
Is there anything?
Both of those are forever.
Is there anything else you'd like to tell Judge?
So that's how serious this is. Go ahead. This is your chance. What do you want to say?
yes, sir. I've been in jail a little while now.
Yes, sir.
I feel I've learned my lesson, sir. I know I've learned.
What have you learned?
I've learned that hanging with the wrong people is a wrong choice. Then I need to get back.
Freedom is a precious thing, isn't it?
Yes, sir.
And your family, life goes on. You're in jail. Life's going to proceed without you being part of it when you're stuck in incarceration. But every mistake has consequences, and you have to pay a price. But it sounds, what you're saying is you're growing up, maturing. But even at 17 and above, you have to have mature decisions, or else you're held responsible as though you were a 40 and 50-year-old an adult. But pointing a gun at somebody and threatening them, that's just a mistake, a click away from the death penalty. Click away. So dangerous this environment is when people get together. And of course, there were 4 people involved, and that the one poor defendant, he didn't have a chance. He had to be submissive. He was going along for the ride. His freedom was lost. And I'm sure he was thinking about, I'm about to die. That's what goes through their mind. And that is a horror that nightmares people forever. That's what they say to me. I think about how I was not in control. Other people were in control in my life. It wasn't fair. And I was about to die. How would you like to go to sleep every night thinking about that? You'd stay awake. That's why it just the harm is long lasting. Finally, state.
Problem I have with all this great stuff that they're talking about and how remorseful and everything is, he had every opportunity with the police to go and tell them what happened and be a witness, and even to help his cousin out to prosecute these other guys. He had an opportunity in the pre-sentence report to say some things. I understand he has a right to remain silent, but if you're really remorseful and you're trying to make this right, you get up and you say, I did something wrong. And it just never happened until we get to a plea to where he's happy with the cap. This is just one of those deals where, where's all this before? You got all these wonderful things that happen at school. Not one time did he tell the detectives, hey, I heard voices tell me to do any of this. Not one time did he say they forced me to do it. And not one time did he go up there and say, hey, guys, I'll help you get these other guys. And that's my cousin. And I'm sorry, but that's not a very remorseful looking person to me. That's somebody that's still got a case pending in Harris County for the same thing and is roaming around committing crimes all over the state of Texas. It's just, I don't care how young he is. It doesn't take much to shoot somebody with a gun.
Anything else?
Just one thing,
Yes,
just so the court will know that on the PSI, I instructed him not to talk about the facts of the
Okay.
case because we.
And he has a right to do,
thought
I'm
that
not
we
gonna
would do it.
penalize him.
I thought we would do it here.
It rewards folks.
Yeah.
If they make statements that
Yeah.
are contrite, but they don't have to. And I'm not gonna penalize them for that, but they get rewarded. You know, if it's true, and it's remorseful, we always look for that. But he has a right to maintain his presumption of innocence, period. And that's, that's pretty special to me. It's not, it's the lead article here out there on it. I'm proud to author that, and I'm going to stand by what I said, what I write. Anything else? If not, all right. Dustin Jones, earlier you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty to this first-degree felony of aggravated robbery. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. There will be an affirmative finding that a deadly weapon, namely a firearm, was used in the connection of this offense. And that will be all rendered in the judgment. You need to, you're talking the talk, but you need to walk the walk of what you're saying. This was a terrible thing. And your relative, and I don't know how, if the family is divided or what, but nonetheless, you don't put a gun to somebody's head or at them, and they don't live that horror their whole life. It's forever. That's what they all say. And nobody needs to be punished consistently. You must do better. Anything else? That is all.
5 years. The judge follows the deal, but makes one thing clear. Talking isn't enough. You chose this path, and now you live with it. A gun, a family member, and a moment that could have ended in death. So here's the question. Was this justice or a missed chance at redemption? Comment below, hit like, and subscribe for more real courtroom breakdowns.